Good afternoon, everyone. It's a pleasure to be here, and thank you for inviting me to talk to you all today. Thank you for the kind introduction as well. I work for a firm of solicitors that's based over in Newbury, and I've specialised in employment law for the last 11 years. Employment law is one of those areas which does change constantly. It's quite vulnerable to a change in the government, having different objectives and ideals with it. But it's also does recognise that there are employee rights and issues that need protection, balancing against the needs of business as well. So because it's quite a wide topic, what I decided to do today is to try and focus on the areas of law that I think are beneficial for you to know a little bit about and what sort of rights and protections it gives you. I'm conscious that it can be quite a dry subject at times, so I will try and just give you quite a high-level view, but if you've got any questions, happy to take them at the end, or I've also got some information out on the front as well, so if it triggers any further questions, you can let me know. So employment law comes from a number of different sources. You've got the European Union rules that we're still following at the moment, and alongside rules issued from our own Parliament. The main piece of legislation that I want to talk to you about today is the Equality Act. This was introduced just over 8 years ago and brought together a number of different pieces of legislation that dealt with sex discrimination, for example, and disability discrimination, all into one heading. So the idea of the Equality Act is to give protection to individuals for discrimination or harassment on the basis of 9 different protected characteristics, and disability is one of those. The legislation itself gives quite a technical definition of disability, but it also gives a number of conditions that are deemed disabilities. So you don't need to work through the definition about having a substantial adverse impact on day-to-day life from the impairment. And cancer and both sight issues are deemed disabilities for the purposes of the legislation. So what does that mean then? So what actually is unlawful under the Equality Act? What sort of protection can you expect? And there's quite a number of different categories of discrimination that are caught within it. So the first or most obvious one is you're protected from being treated less favourably just because you've got a disability. And that's called direct discrimination and would cover, it tends to be one of the rarer types of discrimination. I'll talk about that a little bit more in a moment. You're also protected from less favourable treatment because of something arising from the disability. So if there's periods of absence or that kind of thing, then there is protection that would kick in under that type of claim. There's also indirect discrimination, which looks at sort of policies or procedures that your employer may have in place. There's harassment and victimisation as well. So I'll talk a little bit more about those in a moment, because I think it gives it a bit more perspective if I can give you some examples to go with it. So what does this mean in terms of an actual job, for example? So as I've said, sort of direct discrimination tends to be a little bit rarer because it's often evidential, and people generally don't treat people badly just because they've got a disability, and I hope often that's the case, or where it is unfortunately the case, then there's often a lack of evidence. It's not something that someone would put in an email, for example. So the more common claims are dealing with discrimination as a result of something arising as a consequence of a disability. So the example that I have got here to give you is about a lecturer who was diagnosed with, and my pronunciation may be corrected here, but a hematoma on the brain. He was required to take a period of sickness absence from his position as a lecturer. When he was well enough and able to return to work, he contacted his employer and negotiated a return on reduced hours so that he could ease back into the workplace. So far so good, but one of the terms of his return was that rather than being on his permanent employment contract, he would be moved onto a short-term contract which had shorter notice period entitlements with it. Now, he brought a claim of discrimination arising from a disability because the absence was both necessary as a consequence of the disability that he had, and also the request for reduced hours was connected to the disability as well. And the tribunal upheld that complaint. They agreed that there was no need for the contract terms to be changed in that way. I've got a second example just to explain this point a bit further, which is about an NHS employee. So this was a scenario where the employee was put at risk of redundancy, and it was just before they received a cancer diagnosis. The individual in this claim spent some time off sick, undergoing treatment, and during this time the redundancy consultation was going on. I imagine it's probably quite a large-scale exercise through that employer. And he was asked if he wanted to attend a competitive interview as part of the redundancy consultation. This he agreed to do, but it was during the course of his treatment. And in the end, it was unsuccessful and his redundancy was confirmed. The claim was based on the fact that his performance during that interview was impaired as a result of the treatment that he was undergoing, and therefore the decision to make him redundant was impacted by something arising from his disability. And again, the tribunal agreed. They felt that actually if the decision was based on that process while someone was undergoing treatment, then there was some discrimination within that. So just to move on and look a little bit at harassment as well, because I think it's one of those ones that's useful to have an example or an explanation again to put that into context. So harassment under the Equality Act has quite a technical definition or a quite specific definition again. So it's basically behaviour or conduct, again, that's motivated by one of the particular characteristics, so motivated by disability potentially, that has the purpose or effect of violating the individual's dignity or creating an intimidating, hostile or degrading environment for them to work in. Now, the sort of conduct that could result in that sort of treatment is more commonly in the workplace, perhaps something that's going on with colleagues or where you might need support from your employer to deal with that or those sorts of issues. The example that I've got for you is about an employee that was working for the police, so he's a police officer. He'd had a period of sickness absence as a result of insomnia and stress and was returning to work after that on a slightly phased basis, I think, but it was the return to work interview that caused him the problem. So, as is customary for many workplaces, regardless of the length of time of absence, there'll be a return to work interview. This was held with his line manager. And during the course of this meeting, there were some comments that referred to the individual as being a bit doolally or a bit wonderfully over the cuckoo's nest, according to the case report here. So, at the time, the police officer concerned, I think, filled the awkward silence by laughing along in a bit of an embarrassed way with the comments. But he later raised a grievance about the comments and discussion that took place in that meeting. The Employment Tribunal later upheld his complaint of discrimination or harassment, I should say, in that context, because he was embarrassed by it. It was something that was a remark that was made because of his absence and his illness, and it made him feel uncomfortable in the workplace, and that sort of behaviour shouldn't be tolerated, if you like. The other area where the Equality Act is hugely significant for disability in particular is about the right or duty of an employer to make reasonable adjustments to the workplace. Now, the reasonable adjustments obligation kicks in where the employee with the disability is put at a substantial disadvantage, and the adjustment that's required, there's no sort of definition about what that could be, but it's all meant to be something that makes the environment more workable. So the duty is triggered by three particular scenarios. So the first is where the employer's got a particular practice or criterion, or practice is the technical term that they use. But there might be something that the employer has done, and that phrase is interpreted as widely as possible. So it might be a decision that they've made, it might be a policy that they've got, but if there's something within that puts you at a disadvantage because of your disability, then that's where they should look at what they can do to adjust it so that that disadvantage is minimised. Another one is a bit more obvious. If there's a physical feature of their property which is difficult, so that might be access ramps or something like that. And the last example is just about the provision of auxiliary aids. So the employer might be a reasonable obligation for them to look at providing different screens, for example, if it works computer-based, or perhaps the different keyboard styles and that kind of thing. So one of the areas of dispute that I often find with reasonable adjustments is actually a lot about the sickness absence policy and procedures that the employers put in place. With sickness absent procedures, the Employment Rights Act is what actually puts a requirement on the employer to put something in the employment contract about it. So actually it's not necessarily a piece of legislation that sets out what they have to do for that. It's what they've put in your employment contract, and they should treat all of their employees consistently. Where there can be a bit of conflict about this is that if employees make a request for the policy itself to be changed, that's something that the tribunals are reluctant to say it needs to happen as such, because the policy is applied consistently to all employees. But it's the purpose of that policy that needs to be looked at. So if the purpose of that policy is to maintain constant attendance in the workplace, then that aim or expectation might put those with a disability at a disadvantage, and it's that expectation that might need to be adjusted as part of removing that disadvantage for a disabled individual. One of the things that I've done on my handout that I've left around the front is list some of the examples that the Equality and Human Rights Commission have given as to what might count as a reasonable adjustment in the workplace. There are all sorts of others as well. I will summarise a couple here, but my main point to take away about this, I think, is if you're finding it difficult at work, what I would think about is what the problem is and what practically could be done to overcome that, and present your employer with not just a problem but a solution with it. And I tend to find in my experience that will give you a much better success rate than leaving the employer to go off and try and find out what they can do about it, because they won't necessarily know how your condition impacts you. They won't necessarily appreciate what the right solution is. They might make some assumptions which make you feel worse because they've assumed something about your condition that's not correct. So in terms of reasonable adjustments, that's one of the things that I think is important to think about. And again, the sorts of things we're talking about is this sort of adjustments to premises, or providing information in different formats. So whether it's larger type, or whether it's Braille, or whether it's audio, potentially looking at sharing some of your work. If there's a particular element of your duties that have become more difficult, there might be a possibility to swap with a colleague or something like that. If it's a large employer, there might be an opportunity to transfer to a different role completely in a different part of the business. You might be able to alter your hours of work or work a day or two from home. There might be other equipment or other things that they can do that can assist and support you. So I won't talk you through any more of those because there are quite a number of them, but I want to highlight next just a little bit of a comment about the health and safety legislation, which is another area where an employer does have a duty to look after your health and well-being. And there's some particular obligations depending on the nature of the work that you do. One that quite commonly comes up is about the display screen equipment. So your employer, if you're regularly using computer equipment, they ought to be providing you with regular eye tests. They ought to be contributing potentially to the cost of spectacles if they're needed for you to view those screens, and other support in that area. They also ought to encourage good, healthy use, if you like, of that sort of equipment, and make sure you're taking regular breaks from that. And I guess with the particular condition, I will excuse my limited knowledge about it, but you will benefit potentially from building in more formalised approach to having regular breaks and that kind of thing, I would imagine, if your work was in that way. The other piece of legislation that I think is worth being aware of that deals specifically with rest breaks and working time is the working time regulations that deals with your entitlement to holiday. There are certain rules about how many hours you need to work before you take a break. So it's 20 minutes after 6 hours, or it's 11 hours uninterrupted rest in a day's period. And then lastly, I suspect many of you will have heard of unfair dismissal and those rights. They all come from the Equality Act. They apply to employees with over 2 years continuous service, although if it's tainted by discrimination, then there isn't any qualifying period. So what the employer can do under the legislation is they do have 5 fair reasons that they are able to dismiss an employee for. Those you will have heard of, sort of conduct and redundancy, for example. Capability is one of the reasons within there, and there's illegality and some other substantial reason as well. In terms of capability, I guess that's something that could potentially become a concern if there are issues about being able to perform the job. And that forms into 2 elements. One we can disregard straight away, it's about poor performance and skills, but the other one is about health. And what we have in a situation where an employer feels that health is impacting on an ability to perform the job is they're not able to simply make an overnight decision about that. They ought to seek support and investigate the situation. That might be through occupational health experts. They might look for consent to see whether they need to get any medical reports. They ought to consult with you as well. And usually this isn't something that can happen quickly. It will take a long time, and it's a long period of an assessment. And it should involve the employee within that as well, whether that is the appropriate outcome. If it is a decision that they make, ultimately, the employee would always have a right to appeal. And in terms of redress through the employment tribunal, it's worth noting that they have really short time limits. It's only 3 months from the date your employment ends to be able to bring a claim, and that similar 3 months also applies to discrimination claims. So there's only a couple more points I just really want to highlight for you. Similarly, we've talked a little bit about the time off for medical appointments and highlighted that that's contractual. Again, I think the other point I want to underline with that is if it's connected to a disability, then I think it would fall into a category of reasonable adjustment in any event. So I would expect your employers to be reasonably agreeable about agreeing for absences in that way. And then the last thing to mention really is just a little bit about additional support and other options. So before you're able to go to the employment tribunal, you are required to approach ACAS these days, which is the Government Advisory and Conciliation Service. ACAS's role ultimately is as a mediator between the employee and the company, but they are also a free service, and the mediation part of their service is free, as well as they offer a free helpline. So what they can do, and what you must do before you go to tribunal in any event, is contact them to explain the difficulties that you're having. What they can do is they can go back to your employer on your behalf and explain your point of view, see whether there's any agreement that can be reached. Not necessarily with a view to employment having to come to an end either, just as a way of getting a third party involved, and that can be quite a useful way of getting a different outcome or a different solution if you're finding that communication has become difficult with your employer. And that's it. I think what I would say with dealing with difficult situations at work, communication is one of the things that will make that either a lot easier or a lot harder. And I think being as open as you're prepared to be with the employer is useful, but equally they should know the rights and limits of the legislation as well, and respect that and respect your wishes as well. So that's it. I hope that was useful and interesting. As if anyone's got any questions, I'd be pleased to hear them.